Good morning, dear colleagues, members of the public, and the candidate. Today, on 5th March, the whole advisory group of experts met again to conduct an interview with the candidate for the position of the Judge of the Constitutional Court of Ukraine, Mr. Andrii Mikhailovich Boiko. Mr. Boiko serves as professor of the Department of Criminal and Criminal Procedural Law of the National University Kiev Mohia Academy, and he has been allowed to participate in the competitive selection by the Parliament of Ukraine. I will pass the floor now to the member of the advisory group of experts, Madam Oksana Vasilchenko, who will moderate the interview. Please, Oksana, the floor is yours.
Дякую.
Thank you. Good day, dear colleagues, everyone who has joined our interview. Today, we at the interview have present the AGE members, the chairman of AGE, Mr. Alice Zaller, AGE members, Ms. Hanna Sukotska, Ms. Maureen O'Connor, deputy AGE member Vasil Shakun, and according to the current legislation, today in the discussion of the candidate Boiko Andrii Mikhailovich, the members of the AG participate as Volodymyr Kuzmenko and Vasil Shakun. Also, we have deputy members of the AGE present, Mr. Marek Zubik, Thomas Griffith, and Richard Barrett. In brief, I would like to explain you the order for this interview. The interview is one of the mandatory stages of evaluation of the criterion of high moral qualities. The advisory group conducts interviews with the candidates in accordance with Article 7. Interviews of the methodology in particular to clarify any doubts regarding their high moral qualities of candidates. During the processing of candidate Boiko's file, the AGE sent him questions for him to provide written responses, and we are grateful to you, Andrii Mikhailovich, that you always in timely manner answered in an open way all the questions and was conscientious in the cooperation with the advisory group of experts. Please also note that in accordance with the methodology, the candidate may not provide information, documents, or other materials during the interview if the advisory group requested their provision earlier and the candidate did not provide them within the specified period, or if the candidate could provide them on their own initiative earlier. Altogether, the advisory group may make an exception if it determines that such an exception is justified. I also would like to inform you that the interview is being recorded and streamed live on the AGE resources as well as the CCU website. I remind the AGE members that in case we discuss sensitive data or information or limited access information, we will restrict streaming live. Dear Andrii Mikhailovich, I would like to also inform you that the duration of the interview is approximately 1 hour. The time limit for the response to a question is 3 minutes. At the end of the interview, after all of the members ask questions, you will have the possibility to give a closing statement up to 5 minutes long, and please observe these time limits. I would like to remind you that the advisory group informed you in advance about the existence of doubts following the evaluation of compliance with the criteria of high moral qualities of candidates, and the purpose of this interview is to disprove any doubts about your high moral qualities of candidates. So, dear colleagues, we are starting with the interview with Mr. Boiko. Andrii Mikhailovich, if you allow me, We had questions, and you are informed about this, about your activity. Yes, it was for over 20 years, but we would like to get more details about it. Mainly, we would like you to inform us where you worked in the period from 1995 until 2005. Thank you. In this period of time, I worked in Lviv National University after Ivan Franko, and I held different positions. As of 1999, I was in the position of the deputy department, and as of 2003, I was the dean of the law department. So our assistants, analysts, have identified your income before taxes. That was 200,000 and 2,000 hryvnias, and after tax payments, this was approximately 178,000. And your family consisted of 5 people during this period, you, your spouse, and 3 minor children. If we calculate the expenses for the family's ordinary livelihood, according to the subsistence minimum for each year for this period, it is approximately 146,220 hryvnias. However, during this period, your family, you and your spouse, have acquired a significant amount of property, and here we mean the apartment in Lviv in 1999. In 2000, you purchased an Audi vehicle, and in 2001, your wife purchased a Volkswagen Golf 3. In 2003, your wife purchased an apartment and a garage, also a Subaru Forester car, and then in 2005, you purchased a Subaru Forester manufactured in 2005, and the total amount of money you and your spouse spent on purchasing property exceeded approximately or over $60,000. Please explain. Having that salary, how could you, afford it? Okay, thank you for your question. Well, primarily I would like to mention that my labor activity began back in 1989 after the redistribution. I stayed to work in Lviv National University after Ivan Franko, and in October I was selected as the head of the professional committee of the university, and my salary was 70% of the salary of the provost. So this was a very good salary. And I bought my first car with the money that I earned in 1990. So, of course, I upgraded it. And in 1991, I entered to the... I have entered to the postgraduate course. Then later, as of 1993, I had very active work, and for students, they have organized the ASPI law firm together that existed up till 2000. And as of 2000 till 2007, I was the owner of this ASPI law firm. And clearly that the income from the additional professional activity, apart from the teaching, they were connected with my activity as a co-owner, and not only the co-owner, because for some time, as of 1994 to 2000, I was also the director of this law firm, ASPI. I see. We understand your question, your answer to this question. Madam Hannah, please.
Yes. Let's start with the question concerning the law firm ASPI.
in your written answers, you state that since 1993, you have been a co-owner, and from 2000 to 2007, you were the owner of this firm, and received dividends from the firm's activities. The estimated amount of funds you received in US dollar was $90,300. And we have several questions concerning this situation. First question, who was the co-owner of the ASPI law firm?
Dear Madam Hannah, thank you for your question. So the four students, graduate students, four postgraduate students apart from me, Petros Statyuk, who is the judge of the Constitutional Court right now, but who is resigned now. Andrusiak Taras Grigorovich, he is also the professor at the National State University, and Pavlenko Alexander, who was also the postgraduate student back then. And then in 1996, also we had Andrishko Oleg, who is the professor at the Lviv University now. Andrik Kostyuk, who is a very famous lawyer in Ukraine currently, and the teacher in the Ukrainian Catholic University, and the member of the Senate, Professor Senate. And Volodymyr Osinchuk. He's also a lawyer today. As of 2002, he's the lawyer in Kyiv.
You established this firm, there were 4 postgraduate students, and then they became lawyers. So, and what kind of cases did the firm handle? What was the number of cases? What was your main activity?
Well, in fact, at that moment, the entrepreneur activity was very actively developing. So we have registered many legal entities. And later on, we have been legally guiding these legal entities. And frankly speaking, the volume of work was immense at that time, because many, enterprises with the foreign investments were registered, and we were also registering the foreign investments. And since in Lviv we were the first law firm that was beyond the Oblast Presidium of the lawyers, because the majority of the lawyers operated there. So we had a big flow of those who wanted to establish their business, and they were referred to us. And indeed, we had a lot of work, because we did not only increase the composition of the firm, but we also pay attention that in 1996 we got 4 more members of those who worked with us, and they have become the partners of the law firm. So even in 1990s and 2000, the company that had a big impact and effect on the oblast level also we also had an impact on the way the budget of Ukraine was even generated. So we made big contribution.
Then it was you were very successful, because it was a very successful firm. And what was your role in the law firm's operations, your personal role?
Well, at first, I was the co-owner of the law firm, and for some time I was the director of the law firm, and clearly that I was also guiding certain legal entities in their economic activity where there were some challenging issues. So the partners of the law firm, they were assisting the younger lawyers to follow up the clients, to formulate the legal positions when it was necessary, to have the argumentation of certain positions. So clearly the partners primarily participated in this.
So we can say that you were the main person, the head of the firm, yes, using such such a word. Yes, you were co-owner, but as you said, you were director of the film, so you played a first role in this film. Yes.
Ну, я бы
Yes, I would say it was an active role. Because, frankly speaking, all the four co-founders, we were in the same status. We were PhD students and we had key roles, we played key roles in this forum activity.
In the beginning, you were all on the same status. You were also postgraduate students, exactly. And in what monetary form did you receive dividends? Do you have any documents that could evidence the receipt of funds by you? Because you said it was a very active firm and exactly with many transactions, so how you can document it?
Well, let's pay attention to the fact that this firm started its activity 30 years ago. And in essence, in the year 2000, well, it stopped to be so excessively active, and the volumes and the services and incomes decreased. In that period, fixation of the dividends that we obtained, it was very simple one. So we had a form, we obtained it in bank. There was an accountant in the firm, there was a cashier. The other thing that we should be aware of the fact, and I recognize it and fix it, that we should understand the context. I mean, 1993, 1994, the inflation in Ukraine was 10,000% a year. And we tried to transfer all the money, all the funds that arrived to the firm, we transferred into the cash. Because in the end of the months, all these funds were depreciated, so there were no use to hold them in the accounts. So the context was really very difficult. So I'm aware of the fact that in that period, there was no big qualitative activity as it can be today in accounting policy, in banking policy, was not fixed. And the standards that we have today, they were really very softened and mitigated in that period. And for example, if we had these funds in accounts at the end of our reporting period, we would have had none of these funds in the account at the end. And that's why we tried to the fullest extent to use these funds effectively.
And you know,
я перепрошую, хочу.
I'm sorry, I would like to clarify. Generally, we should understand that when we talk about the accompaniment, legal accompaniment of juridical entities, we should understand that these were cashless operations, so they paid into accounts, they were bank transferred, because these were their expenditures related to our provision of services. But we try to do our best to use these funds not to inflate, so not to permit the inflation of them. And employees and owners also obtained the relevant retribution.
yes, and how the dividends were distributed between you? Because you were, in the beginning, as I understood, 5 persons, yes? You and 4 other postgraduate students.
І
How
я
you
ще
divided
троє,
it,
четверо.
We were in 4, so me and 3 other students. So when we talk about the system of distribution, it was quite a difficult one. There was fixed share from the income for the co-founders. There were some additional payments for me as director. I had additional percentage
because I performed also administrative functions, and the partners had complementary payments related to the profitability of legal entities they worked with. So depending on the volume of funds that came into our accounts, and the partners who accompanied these legal entities from which we obtained income, they had like more retribution.
And can you inform us more and explain why the amount of dividends dropped significantly from US dollar 10,000 in 1998 to US dollar 3,000 in year 2000? It was a case of changing economic situation, inflation. How you can explain it?
Thank you. Thank you for your question, but it is a complex one. In 1998, there was a delicate tension in our firm. There was part of the partners who wanted to perform only legal functions, I mean like lawyers, and they saw only their future career in lawyers' activity, and the other part wanted to combine lawyers' activity and educational activity. So in 1998, 3 partners were separated from our firm. I mean Pavlenko, who didn't defend dissertation because he didn't see himself in scientific activity, and Andrei Kostyuk and Osenchuk, they also quit. They formed their own company, and me, Andrusiak, and Stetsuk, and Andrei Shkolik, Professor Shkolik, we stayed in 4 out of the initial composition. In the year 2000, the situation aggravated because Stetsuk was appointed pro-rector of the university. He said that he couldn't combine these 2 functions and he wasn't interested in lawyer's activity, and Shkolik obtained administrative position in Lviv University. Taras Andrusiak became a director of the law school in Lviv University, and I remained the unique owner in the year 2000. And as I was the chair of the department, and since 2003 I was appointed a dean of the faculty, so it didn't give me opportunity to be active in my firm. And you understand that it led to the decrease of efficiency. And in 2007 I decided to alienate it. But I took this decision even before, because I was occupied in my activity as a dean of the Lviv University, and it was impossible for me to combine these 2 activities. From other point of view, there were some ethical issues that aggravated my activity. So I started to be perceived as professor of the university, and the status of Lviv University was quite an influential one in the region, and I understood that it can essentially contribute to my reputation and image, and it can aggravate and complicate my university work. So that's why I had to choose, and that's why I chose academic activity.
It was the case why you decided to, abandon the law firm, which in the beginning was very successful, yes, but in the end, as you explained, was not so.
Yes, so these factors, these 2 or 3 key factors, contributed essentially to my prospects and my opportunity of the further functionality of the firm. But also I would like to mention that this distribution of the firm in 1998 was quite in a calm manner, in a peaceful manner. I remained in good relationship with my ex-colleagues, and to make it clear for you, I would like to state that I provided notary certified delegations. For example, the lawyer Osenchuk, he was representative of mine in some cases. I had also good relationship with Kostyuk, who today is a prominent lawyer, and he is the head of the advisory board of the Lviv Catholic University, and I am also a member of this council, and we collaborate in a very good manner with him. So I remained in great relations with all of them. It was just a professional decision that had its own reasons, but it didn't mark the character of our relationship in between.
Also, another one last maybe question. You can explain us more, because when you received US dollar 1990 almost 100,000 in dividends, and this money, as you explained, was basis for your cash savings. Why you decided to buy a Subaru Forester on credit in 2005? I don't know. Yes, how was the financial operation done?
Дякую.
Thank you. It was only a partial credit, because 60% I paid immediately. Also, I had some, I would say, relations with this bank, if I can say it. I had a deposit there with an agreement, and also I presented the copy of the agreement with the bank. And one of the employees, or one of the managers of the bank, they advised me to take this partial credit because maybe there will be an exchange this difference because it was increase of the exchange of euro and dollar decrease. So, and partially, yes, it worked out. So I can't say that it was like a successful operation, but some percentage of the credit was covered with this exchange difference. From other point of view, I would say that part of the funds, I mean essential part of the funds, was given from me to Mr. Pavlenko, who just opened 2 investment funds, one in Ukraine, one outside Ukraine. So he asked me to borrow a sum of funds for supporting his activity.
For your explanations. Thank you. For me, it's okay.
Дякую. Андрій Михайлович,
Thank you so much. So please, let's return to your declaration for the year 2016. You declare ownership of 160,000 USD and 250,000 hryvnias in cash, while your spouse owns 40,000 USD dollars. Can you explain what is the source of income? Thank you so much. So, as for my wife, her funds were related to the sale of the automobile that she had sold. After she had funds from the renting apartment, and there is also an agreement. I presented it in the materials. So one of the apartments was in rent, and she obtained amount from this activity. As for my funds, these were my savings for all this period, and also my savings from the period after 2005. Out of the materials that I have presented, you can see that since 2005 I had quite good income from Lviv University, from the position of the chair of the department and function of the dean of the faculty. I performed also some complementary functions in other universities where I gave lectures And all this is reflected in my incomes that I have presented for the experts. Thank you so much, Mr. Andrii. And I would like to drive your attention for that next questions will regard the sensitive information of the people related to the candidates. That's why we restrict the streaming. So please, let's stop the streaming.
Microphone. Now, so we have discussed sensitive issues that refer to the relatives of the candidates. So now we can resume streaming and we can move to the discussion of other questions. Andrii Mikhailovich, according to the information held by the AGE, we see that your daughter, Boiko Natalia, received a gift of real property worth around $127,000 in 2012, and your other daughter in 2013 received a gift of real property worth approximately $67,000, and in 2019 she received a gift of real property worth approximately 23,600 USD. Please tell me who your children received these gifts from. Okay, thank you. When we speak about my daughter Natalia, in 2012, she got a gift of apartment that was purchased in 2003, and all of the documents have been provided by my wife, and this was related to our daughter in 2012 having graduated from the university in Berlin, and she completed the master program there, and we planned that she would return home and that she will continue working in Lviv. And so we decided to make this gift to her. Up until then, it was rented, and I already mentioned this, and we have certain documents confirming this, including later on, our daughter also rented it for a year or a year and a half, since after her studies in Berlin, she stayed to work in Germany. So she has completed the energy law training program, and so that German company decided to hire her. So after she has graduated from the university, she stayed to work there. So clearly, when it's family, it doesn't always happen the way you expect it to be. And then in 2014, she went back to Ukraine, and there was the number of energy companies back then who were planning to develop. They planned to gain the gas and the shale gas, and she already worked and lived in Kyiv. The consulting company has rented the accommodation for her in Kyiv, and she worked until the beginning of 2014, when the active activities connected with the revolution began, and the company requested her to return because they could not bear responsibility for her life and staying in Ukraine in such conditions. And the daughter refused, and she stayed working in Kyiv. She participated in those activities, and later on, for some time, she has worked in the law firm. And later on, the administration of the president in 2014 announced the competition for, the deputy head, Mr. Shenkiv, announced the competition for to increase the number of officials in Ukraine. And having experience of work abroad and having completed the master's degree of the German university, she got the seat and worked on energy matters, and then she became deputy minister of energy on euro integration. And this way she began living in Kyiv completely. And then in 2019, we made the decision to she decided to make this gift of this apartment to her sister. So this apartment was a gift to Boiko Christina. But prior to that, the smaller apartment that was purchased in 1999, that has been mentioned already today, I also decided to give it as a gift to Christina. Okay, then I would like to clarify the question. So Natalia received a gift of real property, apartment and garage, and you have approximately was $127,000. But when it was regifted to Christina in 2019, this property was already evaluated as $23,000 USD. Well, we did not do this evaluation. It was done by the experts, and in certain agreements, the experts who did the evaluation are mentioned. Why the price has changed so significantly, it's hard to tell, because, well, clearly in 4 years there were certain changes, and the market, the property market in Lviv changed, and the prices changed for real property, and the 4 years of amortization. The apartment was rented for 4 years since the daughter was not living in it. But no, our participation in evaluation of the amount of this apartment. The elder daughter decided to make a gift to the younger daughter. There was the notary expertise of the cost of this property, so it's hard for me to explain, since first of all I had nothing to do with this directly, let's be honest, since they were grown women back then. The daughters are mine, and they were resolving this on their own. And even if the custom that was paid in 2016, then they could also pay it in 2019. It was a big issue, since my financial positions at that time, were pretty stable, no financial issues. And the elder daughter and the younger daughter, they are rather efficient. One of them has very good income, which is shown in her declaration, and the middle daughter also has a very successful business. So I don't think, the experts made the evaluation, there's the notary confirmation, this was not some sort of manipulation. So, okay, thank you, we heard you. Madam Hannah, please.
Yes, I have the last question to you, but also concerning the apartments. In your declaration for the period between 2016 and 2018, you declared that you had accrued the right to use a 117 quadrat meter apartment in Kiev since 14 of February 2013. The owner of the apartment is listed as the Directorate General for Rendering Services to Diplomatic Missions, a state-owned enterprise. You indicated as the owner of the apartment the State Enterprise General Directorate for Servicing Foreign Missions. What kind of apartment is this?
This is the apartment that is owned by the state, that belongs to the General Directorate. And when in 2015 I was appointed as the member of the High Council of Justice, clearly there was the question on me residing in the city of Kyiv, and the High Council of Justice, and today they did not have the service accommodation then. And then the head of the High Council of Justice, they referred to the Director General for rendering services, and knowing that they had their own apartments that they were offering for the international offices, and they had some free apartments at that time, and I was allowed temporarily, so only for the time when I fulfilled the duties of the member of the High Council of Justice, to reside in this apartment. Residing was based on the agreements that were concluded every month, since this was the temporary residing, so each month a new agreement would be made, and I paid, it was not free of charge for me, so I have paid rent for temporary use.
You declared the right of use this apartment since 2013, and as we heard, you was appointed or elected as a member of the Supreme Council of Justice as late as in April 2015. So it's a difference of 2 years between you started to use this apartment and you was elected as a member of the National High Council.
Насправді це
In fact, this right was the Director General had this right as of 2013. I started living in it as of September 2015. So as of June, when I started fulfilling duties as the member of the Supreme Council of Justice. So June, July, and August, I stayed in hotel. And of course, this was not easy to live in the hotel for this period of time. And only as of September, so it took them 3 months to resolve the question or on the possibility for me as the member of the Supreme Council of Justice living there. And only as of September 2015, I started living in this apartment until April 2019, until until I finished working as the Supreme Council of Justice member.
Thanks for your explanation. I have no more questions.
Шановні колеги, чи є
Dear colleagues, are there any other questions for our candidate? If there are no more questions.
пане голово, будь ласка?
Dear Mr. Chair, please, the floor is yours.
Thank you. I would like to ask the candidate why he was not able to submit any evidence to the AGE about dividends he received based on this operation of the law firm ASPI, because he, in his written answers, explained that he all in all received almost 100,000 US dollars based on these dividends. And this is a huge amount of money. So why there is absolutely no evidence submitted concerning this income? Thank you.
Thank you. Well, no doubt it's a vulnerable matter given today's standards of inspection, any matters that refer to integrity. Let's go back to 1990s. So and I have spoken about this. There was the accounting of the financial operations in the law firms. So it was the paper documentation. When, for example, the funds came to the bank, and this, according to the certain document, they were paid. In the normative acts of Ukraine, there are norm defined for the time frame when they are stored, and that time has already completed. After I sold that firm two owners of this company have changed. And it took me some efforts to find for the next owner that was after me to acquire at least some of the documents that were related to the activity of this firm for that period of time. And no other documents were stored. He was not interested in keeping those documents. And in 1990s, if you got money based on some sheet, like sheet of recipient of funds, nobody stored it, and I did not know that 30 years later I would apply as the candidate for the constitutional body, and I would have to explain how I got the money. So the law firm existed, we paid taxes, no warnings from the tax authorities or the state for our legal firm for the activity of its operation. And it's just what I cannot provide today because of the indicators, because of the factors that were relevant for that period of time. The following director of the law firm told me that all the documents we got from you when the firm was alienated. And it's just that the documents were destroyed because of, because of the limitation periods of the Statute of Limitations. We were not obligated to store them anymore. Moreover, I have submitted the certificate, and Lviv University couldn't provide me information about my income since 1989 and 1998. So it turned out that no information in their archives about the size of the scholarship and the application for the salary paid as of 1994 until 1998, when I already worked as a professor at the university, they did not manage to provide this information. So there was the period of time in the 1990s when the documents accounting, storage of documents, it was not treated as serious as today. And you have to understand, if the limitation periods is over, then the person is not obligated. This is an unfortunate situation for me, because I understand that I have to explain. It always creates some grounded doubt as whether or not this was in this way. And here I should say that those who have experience of law activity in that period of time, you can analyze the volumes of activity that we had, the nature of customers that we provided services to, the transactions on the law services that was provided, the guidance. And in fact, we were one of the first law firm who was that's very interesting, but Mr. Alish, was there anything else you wanted to clarify?
Yes, I wanted to comment this because the candidate all the time refers to the period of 1990s. But in fact, the period we speak about is from 1993 to 2007. The law firm was closed in 2007. So in all this period, for the whole period, you couldn't find a single document which would confirm that you received certain dividends. This is not very much persuasive, I must say.
Well, thank you. Well, the only thing that I had to do probably was to take the certificate from the next owners, that they do not store these documents, informing us, and that they have destroyed the documents. It's hard for me to explain anything because we started declaring in Ukraine as of 2015. So only as of 2015 we had the understanding in any of those who subject to declaration or declaring, we had the idea how to store document about your income, that you need to keep these records and what is necessary so that you're able to explain it to the society and other interested bodies or stakeholders on what income you had, what expenses you had, to have this full picture about the level of income and property expenses of certain legal entity. But we didn't pay attention before that period of time. I didn't even have such an aim to store these documents or to make copies of them, thinking that maybe one day I would have to explain it, since this activity was legal activity. And it was like a public activity, so to say, because the law firm was very successful for quite a while. And believe me, it was inspected, audited by the tax authority, at least 4 inspections of the tax authority while I was head of it.
Ja перепрошую.
I'm sorry, but frankly speaking, this is what I cannot procure written documents. Mr. Alish, do you have any other questions?
No, thank you.
Thank you very much.
Follow-up question in the same area? Yeah. Mr. Boiko, just in relation to those properties again, you said that in this period you bought 2 apartments. There was an apartment that you bought in 1999, and then your wife bought an apartment a few years later, and I think these were the apartments that eventually went to your daughters afterwards. Can you, and you will remember these transactions, I'm sure, because you were a young lawyer with young children and were watching money. Can you remember how those transactions were carried out? Did you pay for these in cash out of savings, or how did you arrange those? How did you and your wife arrange those purchases?
Well, it was donation. It was donation agreement. So when a mom just donates an apartment to a daughter, there is a special notary authorization, tax paid, so everything was done, everything was documented. It is obvious that the daughter didn't pay for the mama, so it was donation agreement.
Maybe my explanation was incorrect. The original purchase, when you and your wife bought these properties in 1999 and 2003, were they cash transactions back then? Or how did you find the funds for those purchases in those years?
In 1999, this was apartment in the same landing that I obtained from my university before. So the neighbor died and his 2 sons sold the apartment. We went to a notary, we stated the cost of this apartment, we agreed to this cost, and it was cash operation, so I transferred at the presence of notary. I gave cash to them according to the sale purchase agreement. As for the agreement 2023, in the year 2023, I presented the documents. It was a newly built house where my wife during 2 years paid in installments for the building company, and building company, when finished the construction, they transferred, like with all the documents, this apartment to my wife. There is documented information about all the installment paid and after the documentation of ownership right. Thank you so much. Ms. Maureen.
I just have one question. you have a very responsible position now, and you've enjoyed very responsible positions up to this point in the academia, and you were a practicing lawyer, etc. Can you tell me why you want this position? Why you want to be appointed to the Constitutional Court of Ukraine?
Thank you. In different qualities in the sphere of law, I have been working since 1978 on different positions. I always tried to be very active, and being a dean of the university, I participated actively in different events related to the development of the law education in Ukraine. For the first time, in 2005, I was chosen as the member of the High Justice Council, but I didn't manage to become functionable. Sometime after, during the Educational Academician Congress, in 2014, I again was appointed, was chosen and selected at the same position. I took an oath in Verkhovna Rada, but me and my colleagues, all of us, we didn't assume the function. And for the third time, in 2015, I was selected by my colleagues as the member of the Council of Justice. You know, it was the decision of my colleagues. It was recognition of my activity, and since 2015, I was the member of Constitutional Council. I was the member of the Council on Constitutional Reform under the guidance of the President till the year 2019. Before, I was the member of the Council for the Law and Supremacy of Law under the guidance of the President Yushchenko. So I try to be active and performing my functions in the High Council of Justice. I performed my professional independence, my standing solid position, sometimes very strict one, but I tried to be to the full extent useful for this body. I was the leader of some task force groups as for some complicated questions. For example, when we talked about the definition of some provisions about the delay of judge, or like a recusal of judges during the pre-trial investigation. So we can trace it all, that I try to be useful for the judiciary system all these years. And since 2015, I'm the head of the Law Commission in the relevant ministry. I am the deputy head of the task force group for implementation of the unique examination.
You are reciting your history of involvement, and I understand that, but the motivation to be a constitutional court judge for the country of Ukraine, I believe, needs to be founded in a passion for constitutional law, a demonstrated passion and experience in constitutional law, and a dedication to serve the country of Ukraine and its people. And I don't hear any of that from you. I hear a recitation of positions you've held, but I don't hear the passion. I don't hear the commitment that I would like to see in any person who wants to assume this high office. So, thank you.
Дякую. Ну,
Thank you. Maybe, it was long story, but I wanted to explain that my professional activity with my position was related not only with my personal desire to form successful career. On different positions, I tried to be useful to my profession, to academic society, to public society. When there were no selection procedures, the first proposal to become a judge of the Constitutional Court I obtained in 2014. So the Verkhovna Rada asked me to submit the documents. There was like the upgrade of the composition of the Constitutional Court of Ukraine, but I refused because in the same period there was the High Council of Justice selection, so I decided to dedicate myself to serve in this Supreme Council of Justice. I would like to say that retribution of the member of such council was less than my dean position retribution. So for 2 years, I was paid less than in Lviv University, and it also was one of the indicator why the head of the High Council of Justice tried to help me to find the residing place in Kyiv, because with my retribution I couldn't pay for my apartment. It was quite difficult, and that's why
We've heard a sufficient amount. We've heard a sufficient amount. I appreciate it. I'm going to turn it over to Madam Chair.
Будь ласка, Андрій Михайлович, ви маєте.
Mr. Andrei Mikhailovich, you have 5 minutes for your closing statement for the members of AGE. So my main motivation, maybe I would explain it in more detailed manner. So my main motivation was so you see, there is desire to work, to be actively involved, to be useful, to use myself in this sphere because of different factors. From my point of view, it seems that there are some apprehensions about the efficiency of the functionability of the Constitutional Court if we analyze the number of decisions taken by the incumbent constitution of the Council Court. As for the plausible feasibility of the decisions by the Constitutional Court, so my experience as member of the Constitutional Commission for the years 2015-2019, my experience as member of the High Council of Judges member, my public position, my society position pushes me to advance and to promote my functions and positions to be useful. My academic, my teaching experience. Today I am a professor at the National Academy Kyiv-Mogilyanska Academy, and I am also the professor of Vinnytsia University for a year. So this is obvious that all these experiences of my different courses, they do not regard only criminal law. So I have a course like independence of judicial power, standards and mechanisms of provisions, role of European Court on Human Rights for independence of judges principles, and some other courses that are in the framework of understanding what is the image of judge, what is the contribution of judge should be. I mean the intellectual contribution. How the judge of the Constitutional Court should be active to push his or her colleagues to be efficient. Thank you. Thank you, Mr. Boiko. The interview with Boiko Andrii Mikhailovich is closed. Thank you so much.